Okay, good morning. This is Senate Natural Resources and Energy, and it is Wednesday, January 21st. And we are starting the morning off by talking about portable solar and we're plug-in solar. And we are joined this morning by a number of students. Welcome. I think we're going to be hearing from a couple of you. Is that right? Okay, yeah, great. So well, actually, before we start, let's go around and say who we are so that you know who you're talking to. And then would you prefer to come up together? Do you want to go one at a time? What would you like to do?
You can stay together. Yeah.
Okay, great. All right. So,
Bring a second chair up.
yeah, super. All right.
Awesome. Thank you. Hi, everyone. I'm Senator Ruth Hardy from the Addison District. Thanks everyone for coming out.
Senator Jerry Williams, Vice Chair of the committee and from Welcome District.
And Watson from the Washington District, which is where we are.
Seth Baumgartz from the Bennington Senate District. Scott Beck from Calvert District.
Super. All right. So it's Claire and Sophie. Yes. Okay, come on up.
Can you sit right there?
Yeah.
Right. Yeah.
This is a bunch of chairs.
Okay, hello everyone. I'm Claire Emmanuel. I'm Sophia Garupo, and we're students at Middlebury College with some Middlebury friends with us. And we're here representing SNre. That's a Sunday night environmental group, a student-led environmental and social activist group. We were founded in 2005 by students, and we have since been leaders in a number of initiatives on campus and beyond, including the formation of 350.org, a international climate organization founded alongside Phil McKibben. And our work has included bringing Middlebury College to a commitment to divesting from fossil fuels, attending protests, hosting a number of community-based events and talks, collaborating with local organizations, and engaging students to further the climate movement and advocate for sustainability. Our commitments to our communities, to our state, to the natural world, and to our futures are what bring us here today. So as young people constantly moving around, deciding on career paths, living in temporary housing, going through the lengthy and expensive process of installing permanent solar panels isn't a feasible option. Establishing the right to plug in will allow for the purchase of portable, renewable source of energy, electricity, which will make an impact for people like me. As of 2023, according to Efficiency Vermont, the average Vermont household spends 11% of their annual income on energy, encompassing heating, electricity, and transportation. A household spending over 6% is considered to be high. The energy burden that Vermont residents face must be addressed in accessible and inclusive ways. Additionally, the electricity is the most used energy source in households, accounting for about 40% of total residential sector end-use energy consumption in 2020, according to the U.S. Energy Information Administration. I want to see a future where we don't have to rely on drilling into the ground and extracting fossil fuels from foreign countries, burning gas and oil, and emitting carbon dioxide and pollutants into the air for our energy. I want people like me to be included in this transition. Passing this bill would mean a decrease in energy costs alongside a decrease in carbon emissions.
So we are here today with the perspective of young people, but it's also important that this bill is going to benefit all Vermonters by providing them with a reliable access to solar energy. And a very explicit way of doing so is by addressing environmental injustice. Experts have explained solar energy access as a marker of environmental injustice based on the link between affluence and access as a whole. Across various states, including California, Massachusetts, New Jersey, and New York, 90% of homes with residential solar panels are belonging to households with high incomes. This study has also found that through legislation that specifically is targeting low to moderate income households, there can be an increase in the residents that have access to solar energy. And this access to solar energy correlates to other intertwined environmental and social injustices. This bill can enhance a major social injustice by providing an increased access to internet. Today, access to internet is essential for all well-being. If we're doing remote work, if we're on Zoom, etc. With greater access to solar, this internet access can in turn also be increased. Right now, based on 2024, there were 40,000 Vermonters who still do not have access to reliable internet. Moreover, this is an important bill in creating momentum for future climate justice access. This bill will allow individuals to embark on a solar power journey that is typically pretty inaccessible for many Vermonters. And this can be achieved despite one's income and housing circumstances if they are renting a site. So by eliminating these hurdles from starting to use solar energy, Vermonters across affluence, age, and different socioeconomic statuses can claim autonomy over where their energy is coming from. Access to portable solar provides an essential gateway for sustainable energy and that transition away from fossil fuels. Thank you so much for your time, and we would love to answer any questions you may have.
Super. Any questions? Yeah.
I just want to ask a little bit more about the connection you made to broadband to access to the internet. Is it because if more people have access to lower cost electricity, they'll be able to have internet? Can you flesh that out a little bit more for me?
Yeah, so that was based on a paper by Reams, which is attached in our works cited, which we provided to you all. And that is basically saying just overall more reliable electricity makes it so one, there'll be lower cost, so you can reallocate those funds to internet. And like you said, just with access to electricity, then there's a better guidance.
Okay. And I know you guys have talked about this in your group a lot. Do you feel like people, once you graduate and move into your new places, would you buy these portable plug-in solar panels? Do you think there's interest with your generation?
Yes.
Yeah.
Yeah.
And you can stick them in the back of your car when you move.
Yeah. And with that, there's been some studies that have shown that 75% of Gen Z and millennials have interest in solar. But the number that have access to that is significantly lower. I don't have the exact stat of who has access, but there has been reports that show that it is lower than the interest level.
Can you send us that, or is it in your paper, the 75% of Gen Z?
And it should be, it's
Okay.
not, we can definitely pass it
Okay,
along.
cool, thanks.
No questions, but thank you. Yeah, thank you.
Yeah, thank you so much. Yeah, for sure. Okay, and I think we're then ready to move on. So actually before I go, Jude, do you need anybody's for your, excuse me, you're good with everyone's with names. Great. Okay, so I think we're ready to move to Jane Carter from Vermont Law School. She's with us virtually. No, she had her camera on earlier.
Good morning.
Good morning. It's good. Thank you for joining us virtually.
Yeah, well, thank you for the opportunity, and we really appreciated that you asked us for some feedback on your portable solar bill. So I'm gonna see, I sent, of course, just before I got on, I think I pulled a plug on something, so I ripped out my keyboard and my monitor. But I did send a request to be able to share my screen with you.
We may have permission now to share the screen.
It does appear that I do, so let's see.
Irony of just getting screens shared. Yeah.
Sure why it's not.
Does she see the share button?
I think
Clicking
you're,
on it, okay, there we go somewhat. I'll confess, I'm only used to sharing on Teams, so
uh-huh,
I may just kind of leave it where it is, although I guess I can go to, let me just go to the slideshow.
yep.
If it works the same way,
Beginning.
great, yay, terrific.
Hey.
So, as you all know, I'm Jenny Carter, and I'm a professor here at the law school and senior attorney in our energy clinic, which is part of the Institute for Energy and the Environment. And I know you've heard about us from Genevieve Byrne in the past, so I won't go into any detail on what the clinic does. Although I do always like sharing like the really pretty picture of the law school, because I really do have a beautiful place to work. But I thought I'd start off with kind of just an overview of the things I wanted to touch on today. I listened to, a fair bit of the testimony that's been given, so I don't want to be too duplicative, but, maybe emphasize a couple of things that I heard as well as plug in some holes and try to answer some of the questions that you had presented to us, Senator Watson, many months ago. So, overview. There's so many benefits. There's benefits to portable solar, and companion battery storage, which hasn't gotten a whole lot of discussion, but is really part of, I think the future is those combination of the portable solar along with portable battery storage, and especially for renters. They have been locked out of the market. And I think this is an easy entry point. Not only is it portable, but you can buy a much smaller quantity, in a much PV panels in a much smaller quantity than you typically would for traditional home solar. But I also see that it has opportunities for, businesses could potentially be interested in this, as well as homeowners who aren't really sure, how long they're going to be staying in your home, given that traditional solar does have, the payback period is getting even longer with the elimination of the tax credits. And I'd say the other nice thing about portable solar is because you can buy it in smaller quantities, it is slightly cheaper than conventional solar. We can expect, I bet, some of those prices to start going down as it becomes more widely available and widely accepted. So I do think it's going to provide a nice alternative for lower and moderate income people to at least, kind of have an entry point into the solar market. But there are significant limitations to portable solar, especially in terms of size. Are you guys hearing me okay? I'm getting a little bit of
Yes, unless anyone can not hear. Okay, I think we're okay, so
okay.
we're good.
And feel free to interrupt me at any time, because I'm gonna pretty much do a lot with just the overview slide and then move on. I've got a few other slides that'll just go into a little more detail on a few of the points, but I'll give you kind of the broad strokes first. So there are significant limitations, though, as you guys are fully aware, to portable solar, just in terms of size, in terms of how much you can accomplish with it. It's definitely not going to get you to the place where you're going to have a backup system for your whole house, or be offsetting your own electric bill in a major way. But once again, it is an entry point, and I think it does have a lot of possibilities. And especially we're seeing with some of the companies, they're coming out with pretty significantly sized portable solar arrays and systems that are much larger than what's being discussed in this bill. What you have heard, though, and we'll just reiterate, the biggest concerns with portable solar are safety, I think, and consumer education and protections. So I think, so on the score of safety, I'm not quite sure. I've heard some people say how UL is coming out with a standard, but they really have, although they don't call it a standard, they do have a testing and certification process that came out. It was published in December, but it wasn't released until about 2 weeks ago. So I don't know if you all were aware that that has actually come out, and I'll discuss that a little bit. And I've got a slide or two on that. So they have come out with a comprehensive labeling, or they've come out with comprehensive, kind of testing program and certification program. So I know that was an issue that came up is, sort of, do you want to use the term certification or do you want to use the term listing? And that listing has traditionally applied to a whole system, where certification has applied to just individual components. I will say in the UL 3700, they refer to the whole system testing as certification, which kind of surprised me. So it may be not such an important point in terms of the drafting and 202, whether you're calling it certification or listing, which makes me, maybe I'll just say it right now, I think one of the things you all might want to consider, if you feel that you have time, is actually asking somebody from UL to come testify, because I think they could probably answer your questions certainly better than a lawyer can in terms of safety. And I know you've heard from a number of lawyers. And so I'm going to touch on some safety issues, but I'm going to be right up front. That's, I don't want to get too far out over my skis on that one. But so UL 3700, it does address safety concerns, and it does have one of the things before I realized that it was out there, I started coming up with a whole list of things that you would want to have in terms of information for consumers regarding portable solar, and UL 3700. It is quite comprehensive on all the information, all the safety information that needs to be given to consumers, and how to go about installing them, and the list of laundry things that you shouldn't do, including, don't put your finger in the socket, down to the things that, we hope are common sense. But I'll wait till I do have a slide sort of on the three main safety issues that I've heard about, that you guys have heard a little bit about, and how UL 3700 addresses those. Another thing that I would like to raise, and I'm not quite sure, sort of what your approach was, but it was to point out that S202 applies only to part of the market. It's only applying to, I'm going to take a look at the language. It only applies to devices that have a maximum power output to the electric grid of not more than 1,200 watts. Which I will say is the main one. There are systems out there that are larger than that. And while I understand, I think the impetus for this bill might have been just to not require these small systems to go through the 248 process and get a certificate of public good. But I think probably as you've learned through this, and as we've learned, can you guys really hear me? I'm just getting, I'm getting like all these little scritching noises, but okay. I think the impetus came from trying to give it a simpler process and not having to go through 248. But I think what maybe we've all learned in the process is that in addition to wanting to make it easier, we want to make these systems safe. And so I'm just going to flag the issue that the safety features that are all going to be required for these smaller systems, as written and as Utah did it, aren't going to apply to the larger systems. So I'm just going to flag that as to whether or not that is potentially something you want to address. The other thing is that I want to point out that 248 currently, whether you want to consider maybe tightening it up a bit, because the 248 CPG requirement right now arguably doesn't apply to plug and play systems, even the larger ones, as the trigger for having to submit and secure a CPG is you can't do site preparation or construction until you have secured your CPG. So I wanted to flag that whether or not that is something in 248 you might want to tighten up and make a little clearer. The other issue is what to do about multiple devices. Do you want to, as it's written now, it defines a portable solar energy generation device, and it limits that device to a maximum output of not more than 1,200 watts. Do you want to put any limitations on the number of devices a household or a business can have? And I'll just kind of throw out there that Germany doesn't regulate the number of devices you could have, but it does regulate the total output of your devices. And as you've probably heard, they limit it to 800 watts. So getting towards the end of kind of my list is that, and just like the Utah bill, S202 puts the burden on consumers to determine if their product complies, rather than the manufacturer. And I'll raise the question, should manufacturers or retailers be allowed to sell non-compliant products in the state? And potentially one argument for regulating things on the sales side in the state is that it might be easier to enforce against sellers that are part of who have to register with the Secretary of State's office and are more visible than consumers, because enforcement, I think, is really a question mark for compliance with this law. And not only because consumers may not want to comply, but consumers might have no idea that this law exists, right? I mean, and there are a lot of products already out on the market. The consumers can go online and buy, and I've seen them that they say we're permitted in all 50 states, or they'll say no utility interconnection agreement required, and I think your typical consumer, without a big educational effort on behalf of the state, may not even know, that these requirements exist if they're put into place. And the last thing on kind of my laundry list of things to think about is, should the Attorney General's office be given an explicit directive to develop some marketing restrictions or regulations? I won't say for sure, but I'm pretty confident that they already have the authority to do so under the Broad Consumer Protection Act. But it might not be a bad idea to put some guardrails around, what kind of claims sellers can make about, cost savings and how much electricity is going to be generated, etc. So that's my kind of the laundry list I brought to you today. And then I thought I would just do a little bit deeper dive. And you tell me if I'm running out of time.
Yeah, we have just probably like 3 minutes or so.
Okay, so taking just a step back, because I didn't hear this, you might have gotten it in your other testimony, but I didn't hear it in the testimony, is just to get a sense of what the scale of these are. So, the bill has a limit of 1,200 watts. And I will tell you, I put on this slide the 1 kWh battery capacity power, because that is in the UL standard and UL 3700. They are limiting their definition of what they're considering to, if it's solar paired with battery, the battery has a maximum capacity of 1 kilowatt hour. So here's just a couple of examples. A refrigerator. These are just kind of typical. Like a refrigerator can really vary from like 200 to 800 watts, but 300 watts is considered a fairly standard energy efficient refrigerator. That takes 300 watts out of your kind of 1,200 watts caps. And if you've got a battery that's associated with your solar, you could run your battery for a little over 3 hours. A cell phone, you could, only takes 20 watts, that you could charge for 50 hours. I put in a sump pump because that's why I want to have a generator, and I want to have backup power in my house, is because my house floods and I always have to have a sump pump. I always have to make sure it's running. That takes a lot more energy, and that isn't something that would really be feasible under the constraints of this bill or under the UL listing, because even though 800 watts technically comes under that, there are surge issues. But that just gives you a few examples of kind of how you can compare, like, what are the things you can do. But if you compare that next, let's just say, let's see if I can get it to go to the next one. Oh, no, I'm going all in the wrong direction.
No.
For comparison, a Tesla Powerwall has a 13.5 kilowatt hour capacity, and that's a single Powerwall. And so if you're in the GMP program, you get 2 of those. So that's really what it's going to take to kind of power your house if you are using battery capacity. I just thought I would show you. Here's the UL 3700. Here's the entry, kind of the gateway into UL 3700. It is online, and you can access it for free if you open an account. So if you're so inclined, you can go take a look at UL 3700 for yourself. But it is pretty comprehensive. They don't call it a standard, they call it an outline of investigation, but nonetheless, it reads pretty much like a standard, and they can use this for testing and certification. Again. So there are 3 main, one of the considerations that you might want to think about is in both the UL, they did a white paper that identified safety risks, like prior to adopting the equivalent of standards, their outline. And so, as you probably heard, they identified 3 main safety issues. And my point isn't to pretend that I'm an expert in any of that, other than to say they do require to address these safety issues for at least 2 out of 3. It's going to require new technology to be certified by UL in order to comply with their standards. And so if you think by passing this bill, companies are going to be able to, there is a company out there that said that claims that it complies with UL standards. But that's not even possible at this point. They can't possibly have gotten certified. And so, and yes, Jude, I can post that. I can send it to you. And so I just want to point that out because especially with the GFCI compatibility, from what I've read, you know, that may be a while before that particular requirement is going to be able to be met.
So Jenny, unfortunately, I have to interrupt because
Yeah.
we're to move on. Particularly, it looks like you have one more slide. So
Right.
if you want to briefly talk about that, that would be great.
So, okay, and what I will say, let's see, is what about, so I had already mentioned this, what about the safety of larger systems? There are larger systems out there. But the other thing I did want to point out, the last thing I wanted to point out is in the bill, it says in the definition of portable solar energy generation device, it has to include a feature that prevents the system from energizing the building's electrical system during a power outage. And I am wondering if I clearly that's intended to, you know, say that, you know, it's an anti-islanding clause, but is it intended to preclude? There are now systems, and they're fairly new. They go by different terms, like zero export or what's maybe zero export. I think is the more popular of the terms, but that there are systems that now can trigger the anti-islanding, so they disconnect from the grid. And these are combination solar and battery systems, although it actually can apply just to the solar systems as well, but that they will island. But then after they have disconnected from the grid, they will then re-energize the home, but only locally within the home. And I don't know if your language is meant to preclude those or not. And UL actually deals with those types of systems as well in their certification and testing protocols.
Thank you. You've raised some interesting points and things worth chatting about. Unfortunately, we have to move on because our next witness, are they in the room?
Yes.
Okay, so unfortunately, we have to move on because our next witness has a very tight timeline. But thank you so much.
Oh, sure. And if I can answer any questions in the future, I'm happy to, and I will send this to Judith.
Okay, super. Really appreciate it. Thanks for your on this.
Thank you. Take care.
Yeah, you too. Okay, so we are going to move to Mr. Blair, who is the chair of the Electricians Licensing Board and also with the Department of Public Safety. Mr. Blair, welcome.
Thank you. I'll start by saying Jenny did a wonderful job of laying out the groundwork for me. So our stance from the Division of Fire Safety and my position is, you know, we focused on the UL standard 3700 as an outline, and it's still in its incipient stages of development. And we would like to see some closure on their end in addressing issues like overcurrent, backfeeding, branch circuits, possibly even having to create a dedicated circuit and a specific receptacle type to address those issues. And, you know, There are other NRTLs, nationally recognized testing laboratories, other than UL that may jump in the game or manufacturers may utilize for building and developing a safety standard for. Some of our larger concerns are the overcurrent and backfeeding of existing home wiring that will come in various ages around the state of Vermont. We have a lot of older homes, and by increasing the amount of output or input on an existing branch circuit should be taken into consideration, and we feel that UL will address those issues when they come out with their standard. And that'll probably be in the form of a dedicated circuit and possibly even a dedicated receptacle type for anything that's interactive with the utility and backfeeding. I also feel that with the draft document, we really should be specific in our language, and it should include that UL 3700 standard for now as at least a starting point. And UL calls this a plug-in photovoltaic system, indicating that it is interactive with the utility and home wiring. And the way the language is now with just a portable solar emergency generation device could cover a couple different types of systems, one that is not interactive. So our primary focus would be on the ones that are interactive.
Before you move on, can you say that one more time? That UL refers to them as what now? An interactive?
It as an interactive generation device, but it's called specifically a plug-in photovoltaic system.
Okay. Thank you.
I'm assuming that everybody got a look at that white sheet from UL prior to the meeting, so I won't go over too much of that. If you got a specific question about an area that you might need clarification, I'd be happy to do my best to clarify.
Yes, go ahead. We have a question.
So, it sounds like you're mostly concerned with whether if the devices feed electricity back to the grid. And if it's a closed system and is not feeding back to the grid, then there are fewer concerns. Is that correct, or am I misunderstanding?
So just for clarity purposes, if you're plugged into the house wiring, there is that potential to backfeed into the system. If this is a solar array that is just connected to a battery pack that you're plugged directly into, and it's not connected to the house wiring or the utility in any way, I really don't have much concern with those systems. There's already a number of those on the market with UL listings.
Yeah, but I'm talking about one that you plug in but does not backfeed to the grid. I think that's an option, and as my understanding is that that's an option. So it plugs into a house's electrical system, and it doesn't feed power back to the grid if there's an excess amount of power.
There may be a system that only charges a, say, stationary battery or energy storage device that doesn't backfeed. But I thought the whole purpose of the system that we're discussing today is to also backfeed the utility.
I guess I'm not being clear. There are three things. There's one that plugs in, and any excess energy that's produced that is, say, people are not home and their solar panel is producing electricity, but they're not home to use it. So anything excess would go out feedback to the larger grid.
Mhm.
Then I think there's a system where if people are not home to use it, and they either use it, it either has to go to a battery storage or just is sort of wasted energy. That it doesn't feed back into the grid. And then there's a system that feeds into a battery storage. But all of them are plugged into the house's electrical system. I think you're the electrician, not me, so I'm way over my skis here, but I'm trying to understand where your concerns are, which it's the first one that I mentioned, that if it feeds into the grid, right?
That's our larger concern with this. The latter two you indicated sound very similar in nature to me.
Oh, okay.
Being that they're what we would call islanding or, standalone systems.
Okay,
That would not be interactive with the grid or backfeed.
and if they're the ones that are interactive, if there's a shut off device, or that's what I've heard, that's what I think the UL is recommending, is some kind of, if there's an issue, there's a shut off device. Do you feel like that is sufficient, or is that not sufficient?
I'd like to see what UL comes up with for a
Okay.
standard. So I really don't want to speak to that.
Got it, okay.
Yes, go ahead.
Just real quick, and I apologize because I wasn't paying total attention, but you said something about concern about the wiring in older houses. Can you rephrase that or say that again for me?
Sure, Vermont has a lot of older housing stock, as we all know, and a lot of those circuits are 15 amp circuits. Some of them could be even the old knob and tube. Everybody's familiar with that term, or older generation branch circuit wiring. So when we start backfeeding a certain amount of power into a branch circuit that's also feeding other circuits, the cumulative load on that can exceed the ampacity of the wire. So that becomes a larger concern with the older homes and possibly even some newer homes.
Thank you.
Yeah, go ahead.
Sorry.
And then you go. Okay, you go, it's fine.
So I mean, based on some of the slides that Jenny was just showing us, or Ms. Carter was just showing us, and that we've seen before, there are appliances that use as much energy as what would be produced by one of these. So if there's a home that doesn't have, that has old wiring, knob and tube, my first house in Vermont had knob and tube wiring, it was a little scary. Are your concerns about this device the same as your concerns would be about plugging in some pump or a generator that has the same, or refrigerator that has the same kind of usage, or is it specific to this?
Oh, I think that can be applied to any appliance.
Yeah, okay.
Yeah.
It's just generally old wiring is a problem if you're gonna try to plug in something big.
Right.
Okay, that's why I wanted to understand that it's not specific necessarily to these, it's a general concern with the old wiring in houses in Vermont.
Right. They're back to my screen.
And we let people buy fridges without telling them they can't, so.
Right. We're not the appliance police.
Exactly, yeah.
Right.
So I've got a couple of questions, and really appreciating your suggestions so far, like referencing UL 3700 specifically. And then I'm also appreciating that maybe we should call these what they are referenced as in UL's language. One of the other, just to confirm, so if we reference other nationally recognized testing laboratories, Vermont does not have one of its own, right? Like what I'm hearing from other people is that some states have their own nationally recognized testing laboratory, but we don't have one. Am I correct about that?
You're correct.
Okay, and then other states, some other states, as I understand it, have their own electrical code. Do you govern Vermont's electrical code, or are we, do we adhere to some other electric code, or who enforces that?
So I am the chief electrical inspector. I also chair the licensing board, which is charged with adopting new code. And we adopt and recognize the National Electrical Code.
Okay.
Which with this particular system, I think I counted 6 or 7 articles that would directly apply to plug-in photovoltaic systems. We adopt the National Electrical Code through our Vermont Electrical Safety Rules, and that's done about every 3 years, we hope. And in that, we can make specific changes to the National Electrical Code.
Okay, yeah, good, yes.
Given that, could you send us a link to that and would that to the safety rule, and would that? Is there a role to update that so if there are new systems going in, to make sure that electricians are wiring to accommodate these systems?
So we just adopted the 2023 in November.
Oh, wow, okay.
The 26 is just released. So we are looking at that, and there is a possibility to look at, altering some code articles to maybe accommodate a system like that. I again would like to see what the standard is going to come out with. If I had to write a rule, I would say any plug-in photovoltaic should be on its own dedicated circuit and have its own dedicated plug type that would protect against electrocution or touch safe hazards. Just talking out loud on that one.
Got it.
Yeah,
Okay, thanks.
question? Okay, and then I think we do have to move on to our next witness here, but I guess I also just want to mention, so I have a number of I guess I would call them relatively technical questions, which I would love to send to you and or to UL Solutions or to folks at Bright Saber to find out some answers. Things like, so when these devices fail, do they fail open or do they fail closed? The kinds of things that I'm interested in the automatic shut off device, like from a physics perspective, like how does that work? Like how can you be both exporting power and detecting current in the grid? And those are things that I know just enough to be dangerous with those kinds of questions. So I may put those in writing, and as people have expertise to answer them, that's great. And I realize that maybe that's for people who are experts in these specific devices. But anyway, just wanted to put that out there that there's some physics questions that I'm interested in.
Yeah, those are great questions. And on just a closing note, by not being specific with our terminology or trying to hold to a standard, I'm also concerned with the possibility of somebody with just enough knowledge to be dangerous that's trying to build their own system, right? Buying a number of components and calling it a portable solar unit and potentially backfeeding a utility grid and creating that hazard.
I think that's already happening.
Yes.
I think people are,
Yeah.
we can't.
Yeah.
So doing that, there are lots of people out there. Try to MacGyver systems.
MacGyver was the word I wrote down this morning when I was thinking about that.
No, that was a great show. Anyway, thank you. Appreciate your time and coming to chat with us about this. Really appreciate your testimony. So thank you so much.
Okay, you're welcome.
Super. Okay, so we thank you everybody for being here. We are going to switch topics, and we are So gonna have a reset of our thinking, because we're gonna move on to S212, which was about the permitting process for water and wastewater systems when connecting to a municipal water or sewer system. So for that, we have Chris Concord from ACCD. Welcome. Can you close the door, please?
Morning.
Good morning.
Love short weeks. We can do, 5 days of work in 4 days, but I am here for you.
Thank you. You're so good.
I apologize. I'm a little scripted this morning, because my friends at DC don't want me to go off the rails, so but it'll probably be a little bit more than I normally do. But thank you for having us here, and nice to meet some of the other members. I think I know Ruth very well, and
Senator Williams, no,
nice to meet you, Chris Cochran. I'm Director of Community Planning, and Revitalization, and I work with the Department of Housing and Community Health. It's nice to meet you. A little commercial about what we do. I work with ecology program innovators, and we administer about $40 million in grants and programs. And what we do is we provide technical guidance in system speech communities. We're also really good at creating partnerships to help municipalities charge solve the ever-growing complexity problems that they face. Our work has been recognized nationally and internationally, probably from urbanism, the International Economic Development Council has recognized our work. And most recently, our work on a project called Homes for All was written up by Harvard in one of their housing journals. So more to come on that, but I love the opportunity to come back to you and talk about Homes for All and kind of just more broadly, kind of some of the work that we've done to kind of align our regulatory system, our funding system.
look at it, let's say.
Okay,
Looking forward to
well,
having you back to talk about
thank you
that.
for anticipating my request.
Big thanks.
And of course, we want to make strong downtowns and villages, but a lot of this work that we've done around system alignment is focused on housing and creating housing in the right locations. Thank you for that. I look forward to coming back and talking to you more. Switching to the subject matter, and I'm just going to give you a little stream like, why are we here today? So, because I think many members, Seth knows, plus my Senator Bondards knows well, but maybe the rest of you don't. So, I served on the Act 47 committee, that's a stakeholder group of people who know a lot more about the subject matter than I do. But before I want to get into findings, I want to just kind of step back and say how I came to this issue, because it helps explain what this report does and why we're here. The issue predates me and my work for the state and PHCD, but I became involved in a bill called S101 from 2021. At the time, we were working on a report on a program that we administered called Fire and Housing Projects. And we were asked to go talk to developers and understand what actually really does. And depending on who you ask, you got a different answer. Big developer says, it's this duplicative water wastewater process that is really it's crazy. It's not the fee, it's not the engineering, it's the fact that we have to get a municipal permit, we have to hire an engineer, we have to do all these steps, and then the state is not being timely into approvals, and we can't get our Act 250 permits until we have our full suite of state permits ready to go. So that was a pinch point that they were very frustrated about. And this again, this was 5 years ago, this was a long time ago. I understand since, and Brian Redmond's here from DC, they licked that problem, permits are really fast and speedy now. So I think that one's been resolved. I guess, but the other one, I think, if you talk to homeowners and small scale developers, so the people who are trying to help support infill, they had a bit of a different story. They had this dream of building an accessory dwelling, and they're creating a duplex in their house because they had more room than they needed. They said, it's a great idea, but then when you hit the reality, you talk to your local zoning official and say, you're going to have to get a state permit. You're going to have to hire an engineer. You're going to have to go pay us twice, pay the municipality and the state for what is largely a technical review of the same things. It didn't make a whole lot of sense. And for many of them, that first bit of information was just sit down and like, moving on. I've had better things to go through this process. So it was just a little speed bump that kind of stopped me from wanting to take the next steps. So, given the legislature asked us to kind of identify kind of what the barriers were for housing, we talked with the Senate, and I think the Senate Economic Development Bill put this language to kind of remove this duplicative permitting process in S-101. It passed the Senate, it came to the House. At the time, there was a new member on the committee, Senator Bongartz, and testimony candidly was really confusing. The committee was hearing different stories from different people. And Senator Bongartz was tasked to kind of reach out and say, what the hell's going on here? Like, what is the truth? So I thought we were going to have a 5-minute conversation about the facts, but it turned out to be like an hour-long conversation. And led to kind of many subsequent collaborations that have really kind of helped me evolve on regulations for housing context. So thank you for your interest. I can't believe it's 5 years later, but you're the reason why you're here today. Way to go. Blanks out for a lot of things now. So switching to the report, and that was what I was involved in. I don't want to get into the substance of the bill. But just a point of clarity, water and wastewater is a challenge, and building housing was really hard. But I would say this duplicative permit connection process is not the only thing holding up housing. There are a lot of factors in this. It's a complex process. It's availability of sewer and water, the ability to make a connection, size of the pipes, the cost of the land, the cost of financing, on and on and on. So I would say though, that anything we can do, even if it's small, can help. And our stakeholder group did look at this permit. Now, like, this doesn't make a whole lot of sense to do this twice. So even if this is a small step, I think it is an incremental improvement that will make housing more predictable, particularly in the large municipalities that the scope of the allocation is proposed. A little bit on kind of how we got here. Duplication of the process is by design. DC is just following the rules that you guys make. It's not an elegant solution. I think we can do better. And I would say the goal here at high level is not deregulation, it's appropriate regulation. So the municipalities that have the capacity and the knowledge and the technical skills to regulate these permit connections should, in a partnership with PDC. The core of the report, I don't know if you read it. Who asked for a lot of reports? I'm glad you read them. They don't always be read. It proposes a general permit framework that allows municipalities that want to take on this responsibility to work with ANR or DEC to coordinate these permits. I think that kind of partnership will significantly speed up the process. I don't think, it's appropriate in every municipality, especially the ones that don't have sewer and water systems. They're going to really rely on ANR to do the technical review and the permitted septic systems. They don't want the pollution to happen. We just want the process to be more efficient. In closing toward the end here, I think modernizing the rules may be more significant than any statutory change. DEC's wastewater rules were written in the 80s.
Last revised 2019.
Yes. So there's some older thinking in that, and I don't want to ask DEC to do a bunch of work, but I think there's some opportunities to modernize the regulations so that it is easier to come across the board sewer and water connections. And one of the things that the group recommended in the report was modernizing and also creating specific standards for design manuals, make it a little easier and less engineering for every solution that you need. Basically have a book and then like, oh, here's what we need to do for this situation. So it's not paying for one-off solutions that are actually pretty standard. So compiling those, I think, and creating a roadmap for permitting these connections would be a huge step in the right direction. Capacity is the real constraint. Many of our towns that have sewer and water systems have a capacity constraint, whether it's a plant or whether it's physically the size of the pipe. And that's why programs like CHIP that you passed last year are huge. This is really going to, unlock a lot of opportunities. There is a lot of land in downtown village center areas there's often not the capacity to serve. Capacity to serve isn't a really important question that is really murky and complicated and needs to be solved. The way, thankfully Brian's here today, he can talk to you about like, we just don't know what any municipal capacity is because our permitting systems from the state and municipal do not align. And you really need to know what capacity is, because that underlines kind of where we can develop and why we develop. And we just don't have an answer to the question. Perhaps a future study? I don't know, Brian. Be kind of careful. But I just think, figuring out capacity would do far more to unlock housing than permitting on loan or any statutory changes that we do today. That ultimately fell outside the scope of the study, so it's not, I think it was mentioned length. I think John Groveman from the NRC probably has a lot to say about this, but get ahead of him. So in closing, I think the report's very pragmatic. It offers a solution, I think, to this double permitting conundrum that we face. The HEB supports this bill, and given my novice understanding of the EC's rules, I'm happy to ask them more other kind of related high level questions that we have on this number. Thank you.
Great, thank you so much. Yes,
Yeah.
we too. Did I don't recall if I sent to post.
Yeah, I got my copy.
If we don't have that posted on our website, I can get it to you. We'll make sure that it's posted.
It is on your site.
It is on the site.
Last January.
Oh, okay, so it's on the site from last January. There we go. Thank you.
I referenced it. Now you need to read it.
Yeah. Right.
So just to be clear, we're
Yeah.
talking here
Yeah.
about the physical, this is about the physical connection, and engineering around the physical connection, not capacity, not anything else, just whether, and whether we need to have that reviewed twice, right? Yeah, okay.
I'm interested in what you're saying about modernizing the language.
Mhm.
And I don't know if you have any examples of what could be done. I mean, maybe this is also a question for Brian, but it's something that it is also of interest,
Mhm.
so.
Yeah, I can't give you specifics, but I can give you, stories.
Sure, yeah.
Tell me legislative.
Yeah,
But, we work with a group called VCRT, Vermont Secondary Rules Development. They were in Addison County recently, and I don't know if you know about Addison County, but it's full of clays. It's very hard to do in-ground treatment. A local resident was there saying, I'd really like to subdivide my home, but there's really not the student water or the septic capacity in my community, and the rules just don't allow me to do that. As far as what the technical solution is, I will defer to my friend at BC. But I think there's some more modern technology out there where we can pre-treat, we can do a lot of things to get the most that we can out of our in-ground treatment capacity. The technology is advanced from a lot of ways, and I think our roots haven't kept up with it.
super, awesome. Well, glad to know that you all are supportive of this, at least what we have here moving forward, so that's all. Great.
Terrific. Well, I look forward to coming back and telling you about something I actually know something.
We'll look forward to having you back, so thank you.
Bye.
Okay, super. All right, and we are joined by Mr. Groveman digitally, virtually. Welcome.
Thank you. Good morning. Can you hear me okay?
Yes, we can.
Great. I'm sorry I can't be there in person. I'm just juggling a bunch of different appointments this morning. But so for the record, my name is John Groveman. I'm the Policy and Water Program Director at Vermont Natural Resources Council, and great to be before you my first time this session. I'm sure it won't be the last. So like Mr. Cochran and the other witnesses you're going to hear from this morning, I was also on the Act 47 working group, and VNRC supported the recommendations and was supportive of this concept. But I really want to pick up with what Chris said at the end, and kind of put on the table, and really want to hear from Brian Redmond, who obviously runs this program at DEC. But so VNRC is supportive of this concept, but as Chris said, the Act 47 report, which if you haven't read it, I mean, read, and the executive summary is easy to read, and actually the whole report is pretty easy to follow. But it did recommend the general permit approach that's in this bill for a delegation, revising the delegation to municipalities if they have the capacity to undertake it. So there would be a state review or a local review if there was a delegation. But the report also does recommend the issues that Chris talked about, addressing the need for some technical rules about connections, and want to emphasize what Senator Bongard said. This is about connections, right? So it's about sort of the pipe connections and doing it the right way for the system and making sure that it meets the standards of the municipality. And so that report called for a technical manual addressing those connections. And as Chris said, modernizing the water supply wastewater rules with regard to connections. The rules now mostly focus on on-site systems, and there are provisions in there that address connections, but it's not easy to follow and clear, and they do need to be modernized. And so my thought is, and for the committee to consider, is how do we time these things, right? Could we time this new delegation authority in the general permit to the update to the creation of the technical rules manual and to the modernization, of the wastewater rules for these standards? Because I mean, I think for the program to work, you just need to know, municipalities need to know, developers need to know, people connecting just need to know what is expected of them to make the connections. And I would also suggest, and again, really interested to see what Brian at DEC says, but we did talk a lot about capacity. So there's two capacity issues. One is the capacity of the town to accept and administer the delegation, but there's also the issue of capacity that Chris referenced, which is water and sewer capacity. And like Chris, I do not work for a public works department. I am not an engineer. I do not run a water supply or a wastewater system. I'm an attorney who works on policy issues. And I was really, it was surprising that, capacity, there's not one definition of capacity. There are different limits on capacity. There's design capacity in the system. There's capacity in the collection system. Capacity issues are different for water supply systems. You've seen Montpelier have issues with water supply, issues dealing with pressure, right? So that could be a capacity constraint. So I think there was agreement that we need to define capacity and identify the various constraints, and then also come up with a system to make sure we're tracking it better. There has been changes in who and how capacity in these systems have been tracked over the years, and I think it's reflected in the report that just needs to be clarified. I think everyone agrees it's not, we just need to know definition of capacity, what are the capacity constraints, and as connections occur, how much capacity is left in these systems. So if there's a way to incorporate like these efforts, while we're updating the delegation and and authorizing the general permit. And again, I'm not a technical expert, so I think Chair Watson's question was a good question to Chris about could you give examples? I would really ask the Public Works people that you're going to hear from, because they could do a much better job than I could of explaining it to you. But I do know that there are those issues, and I think it would be prudent and make sense to try to, address them as we're, altering the delegation. And then the last thing I want to say is every time we talk about this issue, and we've talked about it a lot over the last 5 years, at least, in the legislature and various committees, the issue of combined sewer overflows comes up. So I just wanted to reference that because I'm sure it's going to come up, and I could give you VNRC's perspective on it. And so do you all know what combined sewer overflow is? I don't want to launch into like a definition of it if everybody knows what it is. I see nods, everyone's
A
nodding.
lot of nods over here.
So I'll skip that part of it. So The concern has been that I think there are, 11 or 12 wastewater facilities in the state that are combined wastewater and stormwater systems. And so when we get severe rain events, and we get more of them now because of climate change, you can get the wastewater plant can get overwhelmed, and then it discharges, combined stormwater and wastewater, and it doesn't go through full treatment. So you get raw or partially treated sewage. So there, I just did it. I just can't help myself. I guess I just, but,
So,
and there have been concerns that if you're connecting to some of these systems, that you're exacerbating those combined sewer overflows. And I've done a lot of research on this, and I'm happy to come back if the committee really wants to do a deep dive into how the state and the federal government addresses combined sewer overflows, because I think it's been a neglected issue, and I don't think it's well understood. And I think so I know my research is, and we've actually had some court cases around this, that I don't think that the state is doing an adequate job in addressing combined sewer overflows. I don't think the state is following the Clean Water Act, which the Clean Water Act basically says that for any wastewater system with a combined sewer overflow, there needs to be a long-term plan to reduce and ultimately eliminate those CSOs. And we've made some progress, but it's been very slow. And you may recall during the conversations about some of the infrastructure funding and the funding that came with COVID, some of that money went to, address combined sewer overflows because it's very expensive. And I think that's why it's gone so slow, because you're changing the piping of these systems that are, 50 to hundreds of years old, right? Very expensive, very hard to do, tens of millions of dollars. But I still think we're going too slow, and I don't think we're addressing it the way the Clean Water Act is requiring it to be addressed. But having said that, I don't think that stopping housing developments from connecting to systems is the answer. And that's not what the Clean Water Act requires. The Clean Water Act doesn't say there shall be no connections until the long-term combined sewer overflow plan is been completely implemented and affected. It basically is a dual system. It recognizes that we have to continue to treat sewers, and if there is capacity, there's that word again, if there is capacity in the system to, during dry flow times, treat wastewater, we should continue to connect people, businesses, housing to those systems. But we really do need to redouble our efforts and move forward much more quickly with these plans. So I don't know. I hope that makes sense. So that's VNRC's view of this. You're going to hear about this, I'm sure. And I do think that CSOs is an important issue, and I think that we need to do a lot better. But I don't think the answer is not addressing connections and having better rules about, as Senator Barngard said, sort of the technical plumbing aspects of making the connections, and to having clear, updated, modernized rules. And if municipalities can achieve the delegation, have a more efficient system where you're either going to the state or to the town. But I do think that's where tracking capacity does come in. I think it would help ease public concerns about capacity. And I think also much more public interaction about CSOs and what we're really doing about CSOs. I don't feel that it's well understood. And I think that's why this issue comes up as part of this conversation, because it's one of the few times that we, from a policy point of view, really intersect with that issue. So that's basically what I had to say. I'm happy to answer any questions.
Well, super, thank you. I don't think I have any questions at this point. Well, actually, I do have one question. So at this point, you are comfortable with the language in the bill as it exists?
What I'm suggesting is, if there could be some time, and I really would want to talk to Brian and others about, is there a way to tie in, along with the adoption of the general permit, language acknowledging that they're going to be the development of these technical rules, the modernization of the water supply rules, to make it just clear what the connection rules are in those set of regulations, and then have something in there about better tracking capacity and who's responsible for it, because there's just I think there's confusion about that right now, or lack of clarity, I guess is a better way to say it. So if the committee is willing, I don't have the language right. I would want to talk to other people. I don't feel like I'm the right person to on my own just come up with it, but I do think that it wouldn't be hard to insert something like that into the bill. And I think it makes sense to do that now if we're trying to address this issue. But let's see what Brian has to say. I would hear
I
from.
apologize. You had said that and I even wrote it down and highlighted it actually.
Yeah, no, it's
Yeah,
okay.
thank you for that clarification. So, I think those are some good suggestions. Okay. Any other thoughts or questions at this point?
So I'm going to listen as I drive to my doctor's appointment. But
Okay.
yeah,
Okay.
I'll spare you the Zoom in my car. So,
No, be safe.
Yes.
yeah.
Okay,
Thanks for the opportunity. Yeah.
no worries.
Thank you.
Okay, so we're gonna keep going in order. So we're gonna hear from Mr. Hanford from Vermont League of Cities and Towns, and then we're gonna go to Mr. Redmond. Okay,
In all offer, I can go later if it's helpful for the technical people, no issue with that.
I think we're okay. What I'm anticipating is, if, let's just go in order.
Okay.
It's fine. If you go, and then we'll go to Mr. Redmond, and then we're gonna take a break, so.
Great. For the record, Josh Hanford, Director of Intergovernmental Relations at the Vermont League of Cities and Towns. And I will be brief and non-technical, so you can get to the people that know what they're talking about. I too was on this working group, went into it, not knowing a lot about this issue, sort of hearing rhetoric, but learned a lot, and thankful for Brian and his team, that led the process and really had good input and a chance for people to weigh in and dive deep into this issue. And like I said, learned a lot about how the state does its process, how municipalities do their process, and the variety that exists across the state for the municipal permits for connection. And really support this bill, the voluntary nature of it. You know, I sort of learned that what the state is looking at when they permit it is the capacity and then the municipality is looking at the capacity to connect. The capacity of the system versus the capacity to connect, and that they both have to work together. They both have different processes, and there are some duplication in processes, but it's not a one-to-one. There's some reasons that both entities play a role in this. So the league is always supportive of when municipalities are granted some delegation of authority. You know, I think we're pretty clear that the existing process really hasn't worked out well. You know, there's been municipalities that have sought it and then given it up. And from my limited non-technical understanding of why, is that the databases never worked. You know, the municipality had these systems in place decades, but then it needed to transfer to how the agencies it just didn't work. It was too much of a burden. So appreciate this new look at it. And as I said, we always appreciate more authority to delegate for delegation of authority at the municipal level. You know, water and sewer infrastructure is one of the most costly and important assets that municipalities have. So they care deeply about getting this right and making sure that they're not doing anything to jeopardize their systems, their taxpayers care deeply about that. And so, you know, taking a cautious approach about this is good policy. You know, the permit fees that are proposed or developed, you know, I don't have an initial like, oh, those are the wrong one. I think we can look at that a little bit more. This sort of technical review aspect of what municipalities, you know, existing permit may have cost versus the new fees for the general permit. I mean, we don't want this to result in higher fees for simple connections, I guess is the way to say it. And so I just want to make sure that we get that right. I'm probably not the right person to answer those questions of whether we've set this up right. You know, some municipalities will choose to seek this, others won't, for very good reasons, and I think you'll hear maybe different perspectives on that. And, you know, we want to ensure that this remains voluntary and that the municipalities have that choice to choose. Removing duplication is always good, and refining how we conduct our processes, taking the time to look at where we've been and how we're doing things is always good government. And so I appreciate that we're doing that here. And really, that's all I have to say. We're supportive of this process. If there's language that changes or some of these technical aspects, we want to, reserve the right to come and talk about some specific aspects of that, but are generally supportive of how this is gone. And as I think others said, this isn't the magic wand. It's going to make porting more housable, affordable to build and connect. It's a good step, and we appreciate the step. Also support what you've heard, I think, from the last two witnesses that, it's always a good time to review those technical permitting issues, and then there are new systems that can meet the needs we have, but, can allow housing to happen in places maybe that the on-site wasn't working in the past. We do support that additional sort of look there. So, happy to answer any questions if you have them, but pretty short, sweet.
Yes, we had to have a question. Oh, Josh, thanks. You mentioned the fees, and that was the one question I had from previous testimony, and sorry I missed some today, but I'm wondering. The $500 fee that's in, the last page of the bill, it was unclear to me whether that was for the state alone, or if that is for a combination of state and muni, or if it's just muni. And do you feel like the municipalities have enough authority to charge a fee, or do they need?
That is one area I think we need a little bit more clarification.
Okay.
And also there was an area about the neighborhood areas and those, I just have a few questions, and probably Brian will clear them up for me, and certainly advice from Harry and, Green Mountain Water and Environment Association. I think we'll figure out, sort of those type of questions, or whether those are the right fees and there is enough authority, because we do believe we do need authority to, have fees that can cover our costs and make sure our technical side of the review to prove this capacity can be covered.
Yeah, I mean, that was my thought too, is the munis need to be able to charge a fee.
Yeah.
The state probably needs to, but we also don't want to have excess. The point was not to raise the fees, the point was to just make it clear who was doing what, so, okay. All right, hopefully we'll figure that out. Thank you.
Great.
Thank you.
Great.
Super. All right, so we'll move to Mr. Redmond. Welcome.
Thank you. Good morning.
All
Thank you for bearing with me. I've been out of connectivity on the glacier, navigating a bunch of different hazards.
right.
So good morning, for the record, Brian Redmond. I'm the director for the Drinking Water and Groundwater Protection Division. So our division is within TDC, within AR. And we oversee regulation of public water systems. So I believe you heard from one of my senior program managers yesterday, Mr. Mountancross. As well as wastewater systems and potable water supplies. So potable water supply being a technical term for non-public waters, and wastewater systems in this context being discharge of treated wastewater to the groundwater. So soil-based water systems, wastewater systems, excuse me. So think septic systems, ski areas using large capacity septic systems to villages, like the village of Rochester is a soil-based wastewater system as an example. Under that program, we also cover municipal connections, so the connections to public water and wastewater utilities we're here to speak about today. I do not have prepared testimony or an intense review of the bill with line-by-line suggestions. But what I figured I would say today is to continue on the historical timeline that Mr. Cochran started and kind of give you an update on where we are at today. So we filed the report, the Act 47 report. Many of the participants are in the room today. And I think the bill that is S212 largely represents the findings of that report. So we are generally supportive of moving forward with the work that we did with the committee. That report was filed with the legislature in January of last year. There was language in the administration's housing bill reflective of the report, which ultimately didn't get picked up in the last session. So we, not having that language move forward, we went to plan B. And so what I want to describe is where we're at today on this issue and moving forward. So part of our budget package last year was a small appropriation of $50,000 to do this design manual and really taken an intensive look at the connection standards for the municipal water and sewer connections, part of our rules. And I will say that in the summer months and ever since really the pandemic, we thought we were gonna see a downgrade and take a haircut on our revenues, and the activity would not, it would slow down, but it was quite the opposite. Our activity has skyrocketed and continued to maintain significant pressure in the program. So during the summer, we are doing one thing, and that is doing our permit. So this connections proposal got a little bit delayed, but we have just rounded the corner and about to release a RFP for consulting services to take a look at our existing standards. And I think you've heard from other witnesses that the standards are really kind of buried in septic system, potable water supply regulations. The connections part of the program is not the primary feature. So the thought with the connections manual is to hire a consultant to really bring those standards forward into a design manual. And one of the professional engineers that served on the committee, on the Act 47 report committee, had worked extensively in a community in Montana that was growing very fast. And in her experience, you wanted to forget if it was Bozeman or Whitefish, one of the bigger towns. And if you wanted to do a water and sewer connection in this town, here's your manual. And our regulations are largely legal and a lot of words. And what we're trying to do is bring those standards forward into more schematics and more of a manual. So that's where we're at right now. We're about to put that RFP out for a request for proposals to have that work done. The other major component of that manual is this investigation of capacity to serve. From a non-regulatory perspective, but to identify the issues that municipalities should be considering when connecting new connections for housing or other uses as it relates to capacity. It is a complicated issue. So we are looking to have, as part of that scope, to start to identify some of the concerns around capacity and some of the issues municipalities should be looking at in terms of making new connections as it relates to their capacity. So those are the two main features of the manual. And what we were planning to do before this bill was introduced was we were using our existing authorities under our existing fee schedule to move forward with a general permit program that would be applicable to all types of connections in all municipalities. So it wouldn't be a delegation program, it wouldn't remove that duplication that you've heard from others, but what it would do would have this design manual to standardize the connection process, really a guide for use by consulting engineers and the people that are doing the design work for the connections for the municipality or for the applicant to apply to the municipality or to the state. So really just try to streamline that process and move. We have significant provisions under Title 10, Chapter 64 relating to deference of licensed professionals. And so we would be moving this program more to a deference type of certification general permit program. So that's the path we are on right now. Before this was introduced. So that's really what I wanted to share today is where we're at.
Can you explain more what you mean by deference to licensed professionals? I mean, I know what those words mean, but just sort of explain how you can practice that. What do you mean in practice?
Sure. So these are, again, we have not designed the general permit program, but in generically speaking, these are professional engineers that are licensed in the state to perform this type of work. These are relatively straightforward projects in the scheme of things. And the capacity to serve is not as straightforward, but the actual physical connection is generally relatively, from the technical side of things, relatively straightforward.
Okay.
So what we would be doing is a certification program that the designer or the consultant has met the requirements and the standards and the rules, which are bolstered by this design manual, this guidance that makes it easier to follow.
Okay.
I think it's a critical piece because, as you've heard from others, the standards are really kind of commingled with technical standards for septic systems and water supply ones.
So if a licensed professional who's licensed and in good standing uses the manual, the design manual, and follows the design manual, then the assumption is that everything is okay. Is that what you?
Plans and specifications would still come. We would still have the right to review, but the idea, and I said, we are under extreme pressure in our program. And the way I always put it to my team is we're always trying to take small peels off the carrot because
Yeah.
it's not quite where we need to be.
Yeah,
And this would be one of those peels that we would try to streamline this process, move it to a certification statement with plans and specifications. We would issue a permit that would contain conditions. But they would eliminate essentially the in-depth technical review.
okay, got it.
Yes.
You're talking about certifying engineers
We are talking about,
for in order to be eligible for the general permit, the chamber would have to go through a certification program.
they're already licensed to perform this work in the state, and so that is who is filing the application on behalf of the applicant, so that is a requirement of the application. And we're just using that licensure to say that, providing deference to those licensed professionals to submit and certify that they've met the requirements of the rule and have used in reference the manual that we're working towards.
So the certification is the engineer certified. Yeah, okay.
Another question?
So a lot of, I had a constitutional company last summer, with a problem that, you know, they were trying to do some improvements to their facility, which included about 7 different septic systems. And they finally got through the Act 50 process. Act 50 said, yeah, go ahead. 2 days later, DEC came in and said, no, you can't. So do you have these entities on the radar that would be required to fall under this general permit? They're obviously big enough that they probably should, so that they know going into it, yeah, okay, you got approved this time, but you know, the next time you apply, you're gonna have to change standards that change. Do you have any mechanism to identify those entities that I'll talk about?
Yeah, so in terms of the general permit, the applicability that we would be planning for is for connections to public water systems and public wastewater utilities. So that is a defined universe. Those entities are permitted through their individual permitting programs. So yes.
Yeah, this entity
This is
doesn't have.
different. Yeah,
They
this
don't
is
have that
different.
capability, there's nothing hooked to, so. They're
Yeah.
kind of gonna have to build their own system, and the feedback I got from the people that contacted me was, you know, if we'd known that 2 years ago, we would have started planning for, they have an engineer on staff. I'm just concerned that those guys may slip through the cracks and.
Yeah, it sounds like, based on what I'm hearing, is that type of project would not be eligible for this
Okay.
general permit. And, you know, part of this is the communications and producing materials that are clear, accessible, transparent, all those things that go into standing up a solid program. And yeah, that would be part of this. Our idea is to get the technical work consulted, contracted through a professional engineer. Get that report, and then the state would do the work of actually building the general permit, which we have done in other programs. Like I give the example of our public water supply program. We have a construction general permit for water mains, which historically used to take a long time. And they would be backlogged into a pile, but we want to see the water mains replaced. And we moved in this direction with general permitting. It's been a very, very popular and well program.
So I have a couple of questions. So appreciating that you all moving forward in I guess I call it like a similar direction under the authority that you have. If we were to move forward, and I also appreciate that simultaneously you're supportive of the bill. If this bill moves forward, how do you anticipate your current path either changing, or can this deference to licensed professionals, does that dovetail with this? Like how would you picture the work changing if we move forward with this?
Yeah, I think if the bill moves forward, I think there's probably some issues that we would wanna talk about. Some of them have already come up with fees and specifically. I think it's gonna have very limited applicability. Based on my understanding and discussions with municipalities, and then our previous experience with our delegation programs, generally people do not do this. That's been my experience so far. Both our delegated programs were in Colchester and Charlotte, and both of those programs got turned back to the state. Not cost competitive for the services that we can provide. So I think it will have limited applicability, and I think the path that we're actually on right now has much wider applicability. And they could work in concert. They really could. The thing that is coming to mind, I mean, you've heard other witnesses talk about it previously, the big hurdle had been the technology and the systems and some of the requirements on delegation. And maybe there's some tweaks to be made there on partial delegation. A lot has changed since, it goes back well beyond S101. And we're talking 15 years here, 10, 15 years here, this issue's been deliberated. And at the time, there was firewall concerns, but really since the pandemic, everything that we do is electronic. We have a lot of information coming in and out. We use ANR Online as our system. So I do wonder if some of these hurdles around partial delegation are actually resolvable now. I have not been a fan of the delegation program just because they have not worked very well in 2 instances where we tried them. What the state received back once delegation returned was less than ideal and caused a significant level of effort for us to take those programs back and bring them into the system. The other thing that I would say about the approach for Act 47, which is really important, it's still critical for me, is we are very good at record keeping. And that was really the part about the general permit where that information, the philosophy of that report is that the technical part is wrapped up, everything is done, and then that package is filed in the general permit. Because I think we still want the conditions and the ability to oversee those connections with permit conditions. But the big ticket item there is that we take that information, we warehouse it, plans, specifications, all the permit related documents, and make that publicly available. And that's important for some of the utilities. I think heard from Megan Moyer, she said she works on her system all the time. But really for title attorneys, and if we move off that, I would suggest talking with them because creating a patchwork of where to go for the records, I think would be a step in the wrong direction for the state. I think keeping that consistent, it's all available online, people know where to go. Is a really important element to all of this. What is the building? What is the structure approved for water and wastewater? Where are the pipes located? All really important.
That brings me to my second question, which is about the fees. So it sounded like for particularly larger developments, having a standardized fee, $500 was going to be, for some of them, a lot less. It also sounded like perhaps for some smaller developments, that could actually be more than what would otherwise be expected. Can you speak to that, or if you have any recommendations around the fee?
Yeah, I don't have a recommendation right now. So our fee schedule is based on the flow of the project. And so our it's a bugaboo for the program, but the smallest flow, single family residence, 240, is that 200 gallons per day? Okay, so
it's supposed to be 240, yes.
Single family residence, 306 and 25 cents. Yeah, 25 cents is it's been on it for a long time. But 306.25. So that is an increase for this proposal would be an increase for a single family residence. But then it goes up to 870 is the next, so it should be a larger home. And then it goes up from there. And I think our highest fee category is 13,500. So a lot of these larger projects are in the 10,000 to 13,500 range. So that is a significant savings for those projects. It also creates a hole for us. And that's a concern. I think that the 500 is an attempt to really cover our costs. The record keeping work, the technology, the data management, all of that comes, that isn't effortless. That takes money and investment in the systems. It takes people to manage those systems. So it doesn't come without a cost. So that fee is essentially trying to cover that cost from our standpoint. Recognizing we're creating a hole by doing this, and trying to recoup some of that. Part of my thinking is that, by creating a new product, this general permit, we actually may see more activity than we do now. So that it's a balancing act, but I do think that I don't have a specific recommendation. I think that that's something that should be discussed.
So as a practical matter, under this program, which by the way, makes good sense to me. But I think it's a different approach to get in the same place as far as vision. But is it the case that you will be much more likely, because right now, most firms that go ahead, my understanding, actually don't get reviewed. And that you would be much more likely to review the connection mechanism for a large project than you would for a smaller project.
Yes.
Yes, so that would provide some rationale for having at least somewhat of a price differential. Perhaps.
Yes, we are I call it a permit factory. We're issuing 2,900 permits on average. I think we hit almost 3,000 permits this year amongst 9 staff, and 2 of those are working supervisors. The math is brutal. And so I think that the reviewers in the offices really know who they're working with and know how to use deference to their advantage to meet the needs of the applicant.
They know the engineers that fix us. Yeah. Okay, I think this general permit, the presumption of deference, is intriguing, and they may get us a lot further along the where we're trying to go in this the issue of delegation. So, okay, yeah.
Yeah, I think it'll have a broader applicability, right? We're really talking about rolling out something that's statewide. It's not going to eliminate that duplication, but I think you'll hear from Harry Shepherd in a little bit. And one of the findings of the committee with the municipalities and the state in the same room talking about this issue is that our standards, we're reviewing for our standards. The municipality may have a different knowledge or interest in their system that they know the course. And they may be looking at a different element that's important to them in that location. So I think I think streamlining is good, but there is some benefit to the duplication. We have different, I always say it takes a village. We're in it together, but we have different roles and responsibilities.
Yes, go ahead.
So I guess I just want to be clear based on some of the questions that Senator Bonders was asking and some of your testimony. You're supportive of the bill, but it sounds like you're not 100% sure whether it's necessary if you're going to this general permit deference model, which I agree sounds like a good direction. Is that true? You're not.
I think that's accurate. Yeah, we've made a pivot after the outcomes of last legislative session. We got the appropriation to move forward with the manual. We're all in on that. We feel like that's very necessary. And we have under our existing authorities the ability to issue general permits under our existing fee schedule. And that is our plan.
Okay, so if this bill does not go forward, you're still going forward with all that stuff.
It's a peel off the carrot.
It's a peel, I like that image. But if we did move forward with this bill, are they, do they work together, or does this get in the way of the other thing?
Yeah, I think it could. It could for those municipalities that want to undertake technical review. Alternatively, I could investigate this, our current delegations, partial delegation. So full delegation is the full scope of the rules, all the septic system permitting, and that's what Colchester and Charlotte had, all the water supply permitting, the full scope of the rules. Partial delegation, which we actually never had somebody come from the door for, is just for the water and sewer connections.
Okay.
And the historical reason that I have heard has been this issue around the data management requirements. So maybe that is more navigable now that and a lot has changed since the pandemic.
Yeah.
Everything went online. We weren't.
So you would have right now partial delegation authority. You could partially delegate just the connections for water and sewer to Colchester if they wanted to come back and just do that part of it under current law.
I think so. I think that I would want to, I've listened to Megan's testimony in your report, and I think I would want to talk that through with her, because it sounds like Burlington may be interested.
Okay.
And there may be others.
Yeah, that's what I was gonna ask Josh, was how many municipalities are interested in this, or is it just Burlington, or, are there more throughout the state?
I'm not aware of anyone.
I don't wanna try to solve a problem that's not a problem. But at the same time, if this is helpful with what you're also doing, then we should do it, because it seems like, aside from the fees, most people are on board with this, but I don't wanna feel good about something if it's not really actually doing anything.
I do think it will be pretty limited, but it's at least a start. You never know, if something, gets rolled out, maybe there's more interest in that.
Yeah.
And Josh has other.
Okay. Thanks.
Okay, any other questions?
Just to
Yes.
make sure we're clear about this, but no matter what happens, you believe that the state should be the repository for all connections with them.
The record, because I can only imagine if we created a patchwork, it would be getting calls from title attorneys like. Upset about closing, and I don't know, is that Burlington's records or is it in the state system?
And that is what's envisioned in this bill, is for the data to stay with the state.
Sure.
And so, and also, for the general permit process, so if I was understanding right, so it's your understanding that you all have the authority to create a general permit right now as it is, which is what this.
Piece gets.
Okay. All right, thank you, it's great. All right, so with that, we're gonna take a quick break. Let's break for like 5 minutes. Whoa, sounds fun. Okay, wonderful. This is Senate Natural Resources and Energy coming back from a break. And we are sticking with the same topic. Gonna go to Mr. Douglas, who's with DEC. Welcome.
Thank you. First, if I make do a sound check, but the mask, can you hear me okay?
Totally fine.
Oh,
Thank you.
yeah.
Good question.
Thank you. So I'm here, basically, I work, with the Drinking Water Groundwater Protection Division. I work directly for Brian Redmond. And I manage the, wastewater system and potable water supply, program that we're talking about here, that Brian mentioned, that regulates municipal water and sewer connection, as well as other wastewater and water supply issues. I have a little background on me. I've been in this role for almost 5 years, come this April, and previously I worked for the same program for 10 years, but from 85 to 1995. And then I took 26-year sabbatical in the private sector and worked as a consultant to municipalities and a professional engineer with my own consulting firm, worked around and worked in at least 6 other states on wastewater and water supply projects. So I'm really glad to have this opportunity to come back and kind of contribute some of the big picture thing. But one thing I also involved in, and I've been all along, but is in developing regional and national documents and guidelines. And one example is the New England Interstate Water Pollution Control Commission that the DEC has been part of for probably almost 50 years. Sets up writes a guideline, a technical guidance document for engineers in municipal waste, that's a wastewater side. And so I just finished a role on a subcommittee reviewing the subchapter, the committee for each of the different subchapters of wastewater management. And so I was on one of those, but it's coming, a new document is coming out in the next few months. And to segue into that, each of our municipal water supply and wastewater connection subchapters in the Environmental Protection Rule, Chapter 1, that we follow, has a list of example national and regional standards, such as the American Water Works Association for water, Water Environment Federation, National for wastewater, and New England Interstate Water Pollution Control Commission is right on that. And so it's really, we are using some of those examples right now. The American Water Works Association just adopted a water budget calculator to recognize the benefit of low flow fixtures and how you can design water systems for multifamily housing, and single family and multifamily housing, but it really has a water savings benefit for multifamily units with a modern design that's based on data that was collected since the country went to low flow fixtures in the early 1990s. Another example is we're involved in a number of municipal wastewater projects under the American Rescue Plan Act. And a number of those are going with a small diameter liquid only sewer that's much more cost effective than a traditional gravity sewer that carries everything. But having a separation unit happening at each connection can really save on the overall sewer cost and operational cost of the system. So those are things they're not explicitly in our rule, but we have that caveat that allows us to utilize late state-of-the-art technologies as needed. So really, my main goal here is to answer questions. I have a few prepared big picture remarks, but so the interesting thing is, so we have 5 regional offices. Brian mentioned it. We historically, prior to the pandemic, we issued about 2,500 permits a year. Since the pandemic, we've been in the 2,900 plus or minus. Actually, one year we went over 3,000 permits with our regional office staff doing technical review of water and wastewater systems. The interesting thing is our data shows there's we've issued roughly 250 municipal permits a year in the last 5 or 6 years. And that's down from 300. Brian mentioned that we had some exemptions to our rules in the 2019 rules. We were issuing about 300 municipal water and sewer permits a year, and that dropped to 250, just so it's basically less than 10% of our total workload.
When you say municipal permits, do you mean just the government connections?
Yeah.
Okay.
For both.
Okay. Yeah.
But I say, and this is the context that I understand where, it's some places like Tri-Town Water in Addison County has a large water system, but no municipal. So that, I'm not counting that. I'm counting the municipalities like Waterbury or Berry or
Just connections.
yeah, okay.
Yeah.
So I think one thing to mention is it's important. Roughly about 80% of our permits are for housing. Which is a significant, significant aspect of that. And Brian touched on the data management, how important that is, statewide. Our numbers show that 15 municipalities issued more than 5 permits a year. So it's not, we were talking about what's the population that might be interested in this bill? That's 15, over 5, and then we have again, this is our permitting number, from our database, is that, only 4 municipalities have more than 10 water and sewer permits a year. So that any, Burlington and other larger.
I don't need to be the same.
It's okay.
Or I know what you're talking about. Are you talking about connection permits? Or are you talking about like permits for a system?
Connection.
Okay, connections. Okay.
So
Just wanna make sure.
The
Okay.
2,900 includes both,
Okay.
and then the 250, again, this is our data,
Okay.
that we have, is just
Okay.
give you an idea of scale.
Got it.
Other than that, I guess Brian covered a lot of what I was gonna say, so I'm here as both a technical resource and information regarding the day-to-day workings of the program.
Yes, go ahead.
Sure, so only 15 municipalities have over 5 connection permit
Right.
requests per year. That means 5, it's not the municipality that's asking for the permit, it's the individual who's
Yep.
developing that. Wanting the connection.
Yes.
That is actually like shockingly
Well,
low.
right, it's in the report, just for reference, so there's a graphically show the report. Sorry?
Why is the housing not being built?
And that's the question, is whether everything is cost, right?
And that, but one of those connection permits, it could be a request for a single family home, or it could be a request for a, 100-unit development.
Right.
They're the equivalent, so
Yeah.
to be fair,
Right.
it could be a big development with multiple units.
Right.
Okay.
And we have the data, we could add up the gallons per day and I get a feeling for that.
Okay,
Not only the number of permits, but how much wastewater in the community, we haven't looked at that today.
okay, cause I think that's an important distinction. It's like 15 single family homes, that's only 15 houses, but it could be actually 1,500 houses if they're all under housing or unit developments. Okay, so if this. So the point is that even if this bill passes. It's limited the number of municipalities who may be interested in.
That's consistent with what others have said today, yeah.
Yeah, okay, Are you as excited about the manual as Brian is?
I am.
So I wanna feel the love for
As
that.
as a former designer and currently registered PE, it's just graphics, really helpful. And we listed dozens of requirements that engineers have to make into a graphic on their plan so the builder can know what to build. Wouldn't it be great to, make sure everyone, here's an example, you may have to tweak it for your specific site, but here's an example of how you cross a water line with a sewer safely. What's a pump station, what's required for a wastewater pump station, and so, that I'm very excited about.
Okay, that's good. And you would be an example in your previous work of a licensed individual who would be given deference to because you were somebody.
I was, so I had my own company in Vermont
Yeah.
for about 4 years, yeah, so
Okay. And would this manual be like a living document so that if something changed and that you could change it easily?
So that's the advantage, so basically. It's not intended to be a rule, it's not like the stormwater manual, which is essentially the rule.
Right.
This is a guidance document to show graphically or schematically, as Ryan mentioned, here's how the system could be put together, example of a detail that you need on your plans. And so the appendices are envisioned to be, here's subchapter 10 and 12 in the rule that apply to the, to these systems. So they, if the rule changes, we change the appendices, but we can always change the detail. If it's appropriate, if it meets the rule, we can improve it. If someone says, that detail would be great if it, had this on it, because we often have it, we could do that.
Yeah.
So that's the advantage of a design, this kind of a design manual, as opposed to a regulatory change. These are examples, they're typical examples of it. And it also would outline the general permitting process and the issue capacity, don't lose those threads, which are also important, and we need to advance those.
Got it. Well, thank you.
Yeah.
Yes, go ahead.
So going back to your point about the new technology, that's interesting. I mean, how far out do you think the miners would use that?
We right now we do. I mean, so
So we
basically,
do
the
right now?
rules say right, here's a list, in 1 second of the rule, this National Sanitation, Society of Civil Engineers, National American Public Works Association. If someone else has this accepted, alternative technical standards called, this is actually, it's called, the subchapter is flexible specific technical standards for wastewater systems, as is flexible specific technical standards for water supplies, the 2 chapters on. So we can do that now. It'd be great though, in a rule to address things that we can, do more efficiently now. I think the example of the low pressure, small diameter sewers. It is, people may not be aware of it. It's not explicitly in the rule. The larger firms that are doing these village projects are aware of it and pursuing it because of the cost savings. But it was first proposed, I can remember, was in Cabot in the 90s. Warren actually did it in the early 2000s. They have a hybrid system in their village. They have some low pressure sewers and some gravity sewers. But then, and then on and off, engineers would do it, but it wasn't large enough recognition to make it public. But I think with these, the village of Montgomery, the village of Wolcott, these other ARPA projects that are advancing, doing it is gonna really show the efficiency of it at a municipal level.
The town I lived in 1970, I worked for the company that put the sewer in the village of Pullman. And every time we dug alongside the water mains were running, water main was put in 1898, cast iron and blew out and took the gravel and everything. So if the town, could they put that system in, or could they integrate it with the existing gravity system they have now, or would have to be off to a.
It would typically be a spur, and the issue that Warren had is it's a different type of sewage, when they connect, you have to make sure you account for that it's one has everything in it, and one of them just has a liquid in it, and they have different biological properties, and you don't want that to cause corrosion of pipes. But that just give just an example. The one that I just would like to say that our rules generally are in good standing relative to municipal sewer connections. And we, in 2007, when we got universal jurisdiction, we ramped up an innovative alternative on-site wastewater. For septic systems, we have pre-treatment systems, that allow for overcoming soil capacity constraints to the degree that's possible in keeping everything underground. So I think that right now we're on a good path. I think the focus is what can we do in the short term, and one is clarification and communication, accessibility of the requirements. And that's where the design manual is going to come in. And also we can be if it does meet the rule, we can just put a guidance document out and get broader. The guidance document is a clarification of some, it gives you guidance, but it doesn't change the rule. And that's something we can do that today without a regulatory change.
Okay, any other questions?
I know I've communicated with a few of you over the project, so.
Super, well, thank you so much.
Right, thank you.
Appreciate you taking the time. Thank you for all the permits that you wish.
Thank you.
Uh,
Get a lot more.
yeah.
Is this the Christmas? That's mine.
What you, oh, good, oh, good. I saw it there.
Okay, and so we're gonna move to Mr. Shepherd, welcome.
Good morning.
Good morning.
I'm Sharon Senators. I'm Harry Shepherd. I am Stowe's Public Works Director and Town Engineer. I'm also Vice President of the Green Mountain Water Environment Association. And I served on the Act 47 committee. So I have some intimate knowledge of that process and all. And I will offer that our Green Mountain Water Environment Association has roughly 400 members, mostly water and wastewater operators, but design professionals also who practice in the water industry. And we think we produce about 40 million gallons of drinking water and clean roughly 40 million gallons of wastewater every day. We also manage most of the septage from the 55% of Vermonters who are not connected to a municipal system. Started out with what I would call a village-centric system. And on the water side, it was 100 years old. On the sewer side, it was installed in the late 70s and early 80s. But then in the early 2000s, Stowe invested in major upgrades and major expansions of its water and sewer system. It used to be kind of a village-centric system. Got extended up and along the road to the resorts, and another branch kind of goes off the tracks. And so, because of that major expansion of our systems, we deal with municipal connections daily. I'm a little surprised to hear some of the numbers that the staff reported here. I think in my 15 years in the position, we've dealt with hundreds. Because the sewer and the water became available to so many properties. And so I would like to offer that I support the bill. I think that for the role of trying to reduce technical review redundancies, it probably provides a path forward that could be helpful.
in the challenging permitting process that all developments need to manage in Vermont. I know that there are maybe a few Chittenden County towns that might be interested in taking it on. I would offer that I don't think I would recommend it to our select board. I just realized for what we do, that there's not really a strategic benefit for the town to take on this additional burden. And I should share that because Stowe has been so active in the municipal connections world, that one of the things I shared with the chair when we were out in the hall is that it should be recognized that the towns own these systems. I'm the owner's representative. The state is involved in permitting connections to the town's assets in doing this. And I think that that's kind of the result of Vermont's kind of overall regulatory structure that 50 years old, added with multiple layers, right? But we wouldn't forego connection permits or technical reviews to the state's process. When the developer is gone, and the engineer is gone, and the permitting agencies have issued their permit, we still have a customer. If their water service leaks, that's water loss for us. If there's sewer lateral leaks, it's infiltration for us. Those are dings on our capacity. And so is I've got a uniquely challenging water distribution system and sewer collection system. We're on the foothills of the mountain. You know, a lot of our municipal connections could involve hundreds of feet of pipe and multiple manholes and switchbacks coming down mountains and real sources for potential operational challenges that we manage already. We start at the development review board process. We take a look at the site utility jobs. We see what's being proposed. We have a conversation with the developer and or their engineer about, hey, you know, we're not gonna build a survey there, it's gonna have to come over here and make a connection over there. And we don't want that connection to the manhole if it's gonna become a leaker. You know, we do that kind of technical review already as the owner's representative. One of the things in the report that kind of made me have pause, is it said that we would be doing those technical reviews on behalf of A&R. We're doing those technical reviews on behalf of our ratepayers. And that's how we do it in Stowe. We need to continue to do that because the prescriptive stuff that the regulators are looking at in the WW rules is not that complicated, but it doesn't necessarily kind of really address the kinds of issues that we're looking at. Except for single family residential, every water connection that we need to make these days needs to include considerations for fire protection systems. That's not addressing the WW rules at all. And so the water service isn't like just dealing with domestic demand. It's got to deal with both domestic demand and fire load, how that is managed for protecting the domestic system from a fire protection system. And so we get deeper into the granular details about trying to protect Stowe's water and sewer system interests. And although it may be possible that this evolves where it might be something that might expedite for a development, their wastewater WW permitting process, I don't think it's going to have a significant impact. And for Stowe, the juice is not worth the squeeze for this bill. we would support it because maybe it could advance the way it's structured. It would be very important for us that it be voluntary. If it ever kind of flip the switch to become required, we would have a much more concern, but we see it as maybe beneficial, not for someone like Stowe, and we're doing dozens a year. And I also would offer that, you know, kind of seeing it from my limited perspective, dealing with water and wastewater utilities and sometimes stormwater, because it's, you know, I'm also dealing with highways and things like that, the public works world. The WW permitting process, after we get through with it and going into Brian's department, that's not the critical path for anybody. It's days, weeks. We usually have it pretty well worked out where it kind of flies right through with these guys. It's not like months typically. Now, there may have been situations where there was a region where Brian might have had a problem with a particular employee or whatever, but it's not the norm. I think the process is challenging, and maybe there was ways of simplifying it. Hopefully this does it some, but it's not going to change anything for the kind of technical review we need to do to protect our ratepayers' interests. And so I offer them. I also offer, and I think I want to reinforce, there have been a number of comments about capacity. And the two words that I didn't hear when we were talking about capacity is aged infrastructure. We could have a designated downtown in Stowe's Lower Village, but I'm telling you that our pump stations are running too much when we have high water. And the run times on a Lower Village sewer pump station is such that you guys designate it as a downtown, but I'm not comfortable if we had a big development proposed that we would issue a capacity to serve letter. And I want to differentiate for you guys between capacity and allocations. Allocations is a process that kind of come about in Vermont to kind of keep track of flows in plants, whether it's drinking water or wastewater. And it might not have been tracked by many. I know when we took it on, when I started 15 years ago, we had no idea who was allocated what. It took us years to evolve the database to kind of get that under control. We now know every property, what they're allocated and such. Capacity to serve has nothing to do with what our plant capacity is on. Stowe has 19 water pressure zones. We have a very complicated water distribution system because we have to pump water multiple times to get it up to the market. Every drop of water we deliver during peak periods gets pumped 5 times before it gets onto the remote part of our resort. Every one of those pressure zones has kind of a limit. Elevation, right? We have water stored at this elevation in this pressure zone, and in order to supply 40 pounds to a customer, we can't go above roughly 100 foot below our stored water elevation. That's simple capacity. The development can come into my office and be at a higher elevation than we can serve in that pressure zone, and I have to say we do not have capacity to serve. We have plenty of capacity in our wastewater plant. Can't supply it. And that's the difference between capacity. And I know it's not directly linked to municipal connections, and I know that's the charge of this bill, but for the big picture, in terms of trying to address our housing challenges, aged infrastructure and capacity to serve are a lot more important than municipal connections. I'll be happy to answer any questions.
Thank you, really appreciate that. With the aged infrastructure and capacity, I mean, it seems like the answer there is money. Like to be able to replace that infrastructure. I guess go ahead.
Well, then, you know, we're gonna start building new stuff on top of old infrastructure. And it fails. You're gonna move all that new stuff. Just for a layman's terminology. I went to my, downtown development. They're talking about housing projects and so you know, your infrastructure down there is 60 years old. So you really have to look at that before you start putting, you know, quadruplex on top of it.
I dread the day in Stowe where we will actually, and this is starting to occur. They're in the property because there's so much development desire and stuff. I dread the day I'm gonna have to tell our water and sewer commission, our select board, that we can't support a real housing initiative because of that challenge. We're gonna continue to say yes as long as we possibly can. We haven't seen a project come into our Lower Village district that's of a scale that, you know, would make me say time out. But if we're gonna put 90 units in a 4-story building down in the Lower Village, a guy like me is gonna have to say come on.
I'm also wondering about the the cost to replace some of that equipment. Does thinking about strategies to do that, I mean, one possibility is to say, right, developer, here's an impact fee, you know, if you're gonna do this, then, I mean, I'm not saying that this is the best strategy or even the right strategy, but one possibility is to ask for that. Do you all feel like you have the authority to ask for something?
We don't have impact fees. We have higher water and allocation rates that I think are probably intended to maybe be something similar to an impact fee, but doesn't necessarily come with the requirements like maintaining a capital program and some of what ties in with that. Stowe's allocation fees are roughly $4,000 a bed. We charge $21 a gallon for sewer, $11 a gallon for water. For many years, those were the most expensive in the state. I don't know if that's still the case, but that is how Stowe paid down their debt burden over the last 25 years from the major expansions that the town invested in to advance those. And I think maybe to share add on a little more to that question, Madam Chair. So our Lower Village sewer pump station is something we recognize. It's a capacity challenge. We've studied our capacities, and so I think you understand pretty tight. We have advanced the preliminary engineering study for replacement of that pump station. We've been trying to advance it through the Clean Water Revolving Loan Fund and the intended use plan and the process there. We're on the list. We don't seem to be making any progress on advancing up the list. In fact, I think last year we came down. And a preliminary engineering report is it's a $4.5 million problem. Our existing pump station was in fact in the flood zone. It's elevated. The new one, if we can get it permitted next to the existing pump station, which is what we strive for, it'll have to be elevated at a higher elevation. But securing that permit is not a surety. We've got to acquire more property. And I think that before the dust settles, it'll be a $5 million project, if not more. And generally, you know, that individual housing development isn't going to be able to like take that $5 million problem and make it go away, right? They may participate a little bit. They would to the tune of $4,000 a bedroom in their allocation fees. But that advancing those capacity challenges is very real, and it's a bigger picture issue that I think you guys need to be aware of.
Thank you, it's helpful. Yes, go ahead.
Thank you. Couple questions. I think what I heard from you is you're supportive of the bill, but you're still wouldn't use it. You kind of like the dual review because you have specific things that you're looking for that are your quirks in your system, just to put it maybe bluntly, I don't know. And that the state is looking for different things in their review. I don't, is that, that's what I heard, but.
Well, the state is, they have some prescriptive requirements embedded in the WW rules, 18-inch separating distance between a sewer and a water crossing, or, you gotta do some special things. They're truly prescriptive, right? It's not like the regional engineer is not looking at like, can we really connect to that manhole?
Right, exactly. So what I'm
We're
hearing is,
looking at it and saying, there's no way you're gonna seal that.
right, so that's what I'm hearing from you, is like you have different, and you're not alone, everybody has quirks in their systems. Okay, so my other question, hearing you talking about the infrastructure issues, and I'm a little hesitant to bring this up, but wasn't that the point of the bill we passed last year, the chip bill that everybody seems to love, that was that you're supposed to be able to use that to do these infrastructure upgrades so that then you can do development? That's.
Well,
I'm gonna jump back there, but I mean, like that was what the point of the bill was supposed to be.
I wanna say we're in my Green Mountain Water Environment, we're just thrilled that you guys are recognizing the bigger picture challenge, all right, and chips may be a way forward on that. We've all been, waiting to see how it all kind of unfolds, and some of that is relatively new. The but-for provision. I think there's a provision that's buried in the CHIPS bill that says something to the effect of, we're only gonna be able to allow this investment for this particular project if it wouldn't have occurred otherwise, but for.
Got it, yeah.
And it needs to be tied into a very specific parcel and a very specific development. And there needs to be a bunch of financial analysis associated with kind of proving out that the TIF kind of characteristics of the CHIPS program will in fact pay the bills, because our water and sewer ratepayers shouldn't.
Got it.
And so I think the CHIPS is potentially a good thing. I hope it can be a great thing. But I would recommend revisiting it, because I think you're going to find that a lot of municipalities simply can't figure out the path forward. They're not aligned with a property and a developer who's going to bring in 100 houses, and gotta, we know to serve that project, we need to do very specific things with the sewer collection system, pump station, whatever.
All right.
Very complicated.
We're not doing that bill now, but I just wanted to ask you, because it sounded like that's what you're describing to me, but heard.
Yes, go ahead.
Is this still off as CSO issues as well? No. Okay, you're through that, or you never had it, or never had it. Okay, good for you.
But the real for the CSO community.
Sure, yeah.
Technically, I don't want to get any of them in trouble, but I think that could be an interpretation of the rules that basically say you can't allow that connection unless you got a plan to find panel with CSOs. And
Yeah,
it's like, gotta break through that. If that's a fact, gotta break through that, because we shouldn't be penalizing, solving our housing problems for normal dry weather conditions if they have the capacity, because we periodically experience an overflow and no one likes it, no one wants it. But it can't stop advancing, getting housing developed, particularly in Chittenden County, where many of those CSO kind of systems exist. And here.
And Montpelier,
Montpelier. So.
as it turns out. Yes, go ahead.
Well, just so, thank you, because sometimes we all have to hear the bearer of bad news. I mean, it's not necessarily bad news, it's just being aware that there are capacity issues that we all need to look at before we start doing what we're going to do.
It's very real on the ground.
Great.
Thank you.
All right, thank you. Appreciate your time. So we are, that is our last witness for today. So we are going to